Good morning, friends. I'm Augustus Corbett. I'm an attorney here in the city of Dallas. I practice personal injury, criminal defense, and family law with my daughter at Corbett and Corbett LLP. She and I also started the Lazarus Law and Justice Project, where we fight to free the wrongly convicted. Today I want to talk to you about a civil rights case that is before the U.S. Supreme Court. You may have heard a little bit about this case, so I want to explain a little bit to you about this case. Now, I've been following this case for a couple of years. I recently saw the plaintiff, one of the plaintiffs, on the Breakfast Club, and he was explaining the case. His name is Byron Allen. Byron Allen. I recommend and encourage you strongly to go and watch this Breakfast Club interview. I think it's the best they've ever done. He did a great job explaining how this case came about, how he started his company, how he grew his company, the racism that he has had to overcome over the past 20, 30 years of his company. And so this case is very important, and that interview is very informative. I don't think a lot of African Americans understand the importance of this case, and so I just want to give you just some brief information this morning about this case that is before the U.S. Supreme Court. The name of the case is Comcast Corporation versus National Association of African American Owned Media and Entertainment Studios Network Incorporated. That's a long title, but both of the companies here, National Association of African American Media and Entertainment Studios Networks Incorporated, are pretty much were founded by Byron Allen. The Entertainment Studios Networks Incorporated is his personal company. That's the company that he started sitting at his dining room table, he said. And the National Association of African American Owned Media is a company he started to bring together other African American owned media companies. Okay? And I'm sure you're familiar with Comcast Corporation. Comcast Corporation is this big media empire. It's what's called a distributor company. And by that I mean companies like Byron's company, Entertainment Studios Network. These companies own television networks. They produce some content, like TV shows, movies, but they need the big white own Comcast Corporation, Charter, Time Warner Cable, AT&T Uverse. They need those kinds of companies to carry their programming. Otherwise, Byron's company could not get his content and his shows and movies and so forth before a whole lot of people. So Comcast Corporation is one of the largest. Another company that's somewhat involved in this is Charter, which is also, I think, the second largest. I want to say that Comcast is, second largest in certain types of programming, and Charter is second largest in certain other types of programming. And Byron wants to get his television companies, networks, his TV movies and TV shows on these bigger networks so that more people can see his content and so that he can command more advertising dollars. But they have been refusing to contract with him because he says of his race. So this is a race-based civil rights suit, and that was the reason why he sued both of these companies, Charter and Comcast. Okay, with the Charter case, by the way, he won that case in federal district court. Charter appealed to the Ninth Circuit. Then Byron's company won at the Ninth Circuit, and Charter tried to get that case into the U.S. Supreme Court, but they denied his writ for certiorari. With respect to Comcast, he sued that company in federal court as well. Byron won, he lost that suit actually. Then he appealed to the Ninth Circuit. The Ninth Circuit gave him a victory, and from there Comcast appealed to the U.S. Supreme Court, and the U.S. Supreme Court accepted his writ of certiorari, so they decided to hear his case. In fact, oral argument in the Comcast case is scheduled for I think it's next Wednesday, November the 13th. I plan to be there. I hope my schedule will permit me to be there. So that's what's before the U.S. Supreme Court, and these companies have fought tooth and nail to keep Byron Allen's company and TV shows and so forth off of their lineup. One of them, I think it was Comcast, an executive for Comcast, reportedly said that they were not interested in creating another Bob Johnson. Bob Johnson, if you remember, is the founder of BET. So basically what they were saying is they were not interested in creating another black man to create another, powerful, wealthy company like that. So the racism is pretty clear here, according to the facts that Mr. Allen alleged in his petition and briefs. I've read all the petitions, I've read all the briefs in both cases, the charter case as well as Comcast, and they seem to be really, really strong cases. Now, once again, let me take a drink of water. Once again, the only case that is before the U.S. Supreme Court is Comcast Corporation versus National Association of African American Owned Media and Entertainment Studios Networks, Inc. And the issue, and by the way, two things I want to mention. First, Al Sharpton and his organization, the National Action Network, as well as the Urban League and the NAACP, were also named as defendants in Mr. Allen's case, because he felt like those companies were he felt like those organizations, those civil rights organizations, were hooking up with Comcast Corporation and Charter Communications in a way that was interfering with his ability to get contracts with these companies. Let me explain that. Both of these companies, Comcast Corporation and Charter Communication, were merging with other companies so that they could become bigger. I think Comcast Corporation, at the time that Mr. Allen filed his lawsuit, were trying to buy NBC Universal and other NBC assets. But the FCC needed to approve that merger, and the FCC required diversity with Comcast Corporation. Excuse me. And what Comcast did was they entered into memorandums of understanding with the civil rights organization, including Al Sharpton's organization, the Reverend Al Sharpton. And Mr. Allen felt like those MOUs, those memorandums of understanding, were shams. They were just giving the appearance that these companies were interested in diversity. But he said, how can they be interested in diversity when they are denying African American owned companies to be included in their networks? Now, I must say that I think both of these companies, excuse me, were allowing several African American owned company television networks to be in their lineup. For example, the Oprah Winfrey Network OWN, as well as TV One, and probably BET. But keep in mind, BET and TV One, I don't believe are owned by African Americans anymore. So the only, one of the few, if not the only, African American owned television network that these companies carry is Oprah's company. All right. And that, really doesn't matter. The point is, they are denying Byron Allen's opportunity to be a part of their network. That I don't care if they had 10 other African American owned networks, if they are denying Byron Allen the opportunity to have his company on their lineup, and the issue is race, then that is actionable. Okay, and that's what Mr. Allen believes is going on, and that's why he sued them, and that's why we are where we are. Now, the issue before the court is what must be included in Mr. Allen's petition in order for his lawsuit to get from stage 1 on into stage 2 and so on. And the issue is whether or not, and let me explain something else too. Mr. Allen sued these companies on a civil rights law that was passed back in 1866. It's called the Civil Rights Act of 1866. And I want to read that for you here, if I can find it, because it is the crux of the whole matter. It is the reason why Mr. Allen, it's the reason why this case is so important. You can't really say that this case is now bigger than Mr. Allen's dispute with these companies. It's bigger than Mr. Allen, it's bigger than Comcast, because depending on how the U.S. Supreme Court rules, it will have a major impact on all types of civil rights litigation with respect to contracting. Okay? Now, the particular law that I am talking about is, again, the Civil Rights Act of 1866. It was codified as 42 U.S.C. Section 1981. Civil Rights Act of 1866 being right after slavery. And so the law was passed to help the newly freed slaves be able to start rising up in business, etc. So the law is still good law. It hasn't been struck down or hasn't been repealed or anything. It's still good law to this day, and we gotta protect it, because it was passed, it was enacted to protect us, to help us as African Americans. Now, here's what the statute says specifically. All persons within the jurisdiction, notice all persons, black, white, within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts. That is the important point of this particular statute: to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws, proceedings for the security of persons and property, as is enjoyed by white citizens. That's the point. The law was passed so that all persons, most especially African Americans who had recently, at that time, been freed from slaves, the law was passed to give those African Americans the same right to enforce and make contracts as is enjoyed by white citizens. So that's what this fight is all about. That's what this fight is all about. That's why it is so important. In 1866, it was important for African Americans to have the same rights to make and enforce contracts as white citizens. It's as important today, if not more important, that African Americans have the right to enforce and to make contracts as white citizens. That's what this fight is all about. Because if you're in business, if you are entering into any kind of contract, you want to be treated the same. You want to be able to make that contract. If somebody's in contract with you that you need to enforce the contract, you need to be able to do that as well, just like white citizens. So that's why protecting this law is very important. We don't need the U.S. Supreme Court to interpret this case or hand down a ruling in this case that will essentially gut this law. Okay? Now, I think back to the Voting Rights Act, and where the U.S. Supreme Court, basically the law is still good law, but they gutted it so that it no longer has real effect. Well, that's exactly what could happen with this law. Remember, there are 5 very conservative U.S. Supreme Court justices on the court right now, okay? And many fear that those 5 very conservative justices, Chief Justice Robert, Chief Justice Alito, Chief Justice Roberts, Justice Alito, Justice Clarence Thomas, Justice Gorsuch, and Justice Kavanaugh, okay? Those 5 guys right there, if they get the opportunity to gut this law, they very well may. Many people fear that, and that's why this is so important. Now, the issue that is before the court, once again, is what must be in the pleading. What must be in the petition of someone who brings this lawsuit, okay? There's one standard that's called the but-for standard, the but-for cause. Another standard is called the motivating factor standard. And I don't want to get too technical here, but basically the but-for cause basically means that race is the only reason why the defendant is not entering into the contract. So essentially, let me take it back to this case. Comcast wants the court to say that race must be the only cause, the but-for cause, okay, for them not entering into a contract with Mr. Allen's company. Comcast, let me say it again, wants the U.S. Supreme Court to say that race must have been the only reason why they did not enter into a contract with Mr. Allen. That is the but-for cause. And the reason they want that is because if they come back and say, well, no, race was not the but-for cause, here's why we didn't do it. We didn't enter into a contract with him because we had limited bandwidth, or because his stations, his programming just were not up to par, up to our standards. You know, if they offer something that's not related to race, and the court says that race must be the only reason why they didn't enter into the contract, well then Mr. Allen's case is over. It's done. Okay? And that's the reason why Mr. Allen's legal team is arguing that the standard should be the motivating factor standard. Okay? Which basically means this: race was the motivating factor. There could have been other reasons why Comcast did not enter into the contract with us. There could have been bandwidth limitations. It could have been whatever, but race was the motivating factor. Okay, that protects this law. The motivating factor standard protects this law because the defendant can't come back and say, well, we had these other reasons why we didn't contract with him, and therefore the person's claim is dead because they didn't prove that race was the only reason. Okay, I hope you understand that. That's a very, very important distinction here. All right. If Comcast is able to convince those 5 conservative justices, pardon me, that the but-for cause standard should be the standard, Mr. Allen loses this case, because then Comcast can say race was not the but-for cause. Race was not the only cause. And they would probably deny that race had any cause, although it's hard to deny race when you are on record saying that you don't want to create another Bob Johnson, who is an African American man who founded BET. But anyway, if they get the but-for cause standard, if they get the 5 conservative justices to agree with that, then Mr. Allen loses, because they will say, no, the real reason why we did not enter into a contract with Mr. Allen's company is because of these other reasons. Race was not the but-for cause. If Mr. Allen is able to convince, of course, the 4 liberal justices and 1 or more of the conservatives to stick with the the motivating factor standard, then he wins the case, because because then Comcast cannot say, okay, there were some other reasons why we didn't enter into a contract with Mr. Allen. That wouldn't work, because all Mr. Allen would have to show is that race was a motivating factor. It was a motivating factor. Okay, there may be other reasons, but race was a motivating factor, and that goes against the spirit of the Civil Rights Act of 1866, 42 USC section 1981. It goes against the spirit. It goes against why the law was enacted in the first place. If you're going to make it tough for African Americans and other minorities to bring this type of lawsuit by ruling that they must show that race was a but-for cause, then there's basically there was no point in enacting the law in the first place. You would have gutted the spirit of the law. Okay, so that's why this case is so important for African Americans. All right, we need the court to rule that race need to only be a motivating factor in this type of lawsuit, and it's not the only factor. Okay, that's why this case is important. It could impact African American businesses from any stage, from any industry. It could have a profound effect. So this case is very, very important. Be praying that the justices will reach the right conclusion and hand down a case that does not essentially do away with 42 USC section 1981. I hope you understand. If you're not a subscriber, please become a subscriber of our YouTube channel. I do legal analysis when celebrities are involved, and would love for you to be a subscriber. I think you would learn some things. Okay. Again, I'm Augustus Corbett. I'm an attorney here in the city of Dallas. We practice personal injury, criminal defense, and family law. And we also started the Lazarus Law and Justice Project, where we work to free the wrongly accused. Thank you for tuning in. Please share this and tell your friends about it, and become a subscriber. Thank you. Have a good evening.